Hear ye. The Board of Appeals for the State of Michigan is now in session. The Honorable Christopher M. Murray, the Honorable Ellie Frankie, and the Honorable Michael J. Reardon. All in business herein, draw near, give attention, and they shall be heard. God save the United States, the State of Michigan, and this honorable court. Please proceed.
Thank you very much, Vince. Welcome. We're panel 4 of the January 2026 case call session. To my right is my mentor, Judge Murray. To my left,
blame me for stuff.
It's all him. And to my left is a great addition to the court. Right, 2 years now, 3. Judge Maldonado. Be assured that all of us have read your briefs and we're well acquainted with the facts of your case and everything you've sent us. So don't get up and rehash your brief. Now is the time for you to tell us something that more than what was in your brief, or explain something you may not have been as clear on it as you would have liked to have been. Just don't sit here and fill dead air. Everything today is recorded and will be on video, and you can actually go and look at it on YouTube this afternoon. So I caution you, do not mention the name or location of any petitioner in an appeal involving a personal protection order, or the name of any minor child in a termination of a parental rights appeal. By court rule, each party is allowed 30 minutes to argue, if opposed, or 15 if not opposed. I don't think anyone will get close to that limit today. So without further ado, we'll call our first case of the day, number 12 on our docket, case number 363-131, People versus Robbie Deshawn Taylor.
Good morning, Your Honors. Angeles Meneses from the State Appellate Defender Office. On behalf of Robbie Taylor, I do believe that we are joined today by members of Mr. Taylor's family in the gallery today.
Well, welcome to everybody, including you.
Thank you, Your Honor. Your Honors, I've raised 3 issues in this brief. One being the issue regarding juror number 6. The second regarding the photos of the decedent that were presented at trial. And the third regarding the lack of preliminary instructions.
I'm sorry.
Yes, of course.
I just have a procedural question. The 3 issues that are in your brief are not the same issues that were raised in defendant's pro per application. Is that correct?
That is correct, Your Honor.
Okay. And the Supreme Court sent it back to us as on leave granted.
Yes.
And as you know, on leave granted, we consider the issues raised in the application.
Yes, Your Honor. My understanding of it was a little different because it's true that Mr. Taylor did file some pro per motions for relief from judgment. And then the Supreme Court sent it back for the appointment of counsel. And my understanding from the court was that I would be able to supplement with the issues I saw as well. But if this court would require further briefing, I'm happy to do so.
No, I just think it's that's why I said it was just procedural. I just thought probably the best thing is you file a motion, file a supplemental brief, and you file what you filed, and then file a brief with the arguments that were in the application. That's typically, I think, the way it's done.
Yes, Your Honor. And
not really no harm, no foul. It's just, I've been doing this a long time, and I never have seen it like that.
Yes, Your Honor. And understood. I think it was a different strategy call at the time that the original issues were raised until now that counsel is involved. And that's pretty much all I can speak to. And so I'm going to focus on issue number 1 with regard to the jurors, unless the court has any questions about the remaining 2 issues. Okay.
Go ahead.
Your Honor, trial counsel, the trial court erred by proceeding with trial amidst a juror note from juror number 6 saying that some people in the back of the courtroom, quote, were maybe making the jury feel, quote, a little bit uncomfortable or intimidated. Trial counsel for Mr. Taylor did ask for this juror to either be made an alternate or did reference the possibility of a mistrial, did say, I don't think this court wants to do that, but that would be the logical next step, or however it was phrased on the record. And Mr. Watkins' counsel, which was co-counsel, asked that the jury be voir dire to assess the issue. So this issue is preserved before this court. It was raised at trial. Jurors number 6 sent a note indicating that there were some people in the back. He was not sure who they were affiliated with, whether they were affiliated with Mr. Watkins' family, Mr. Taylor's family, or none of those. Indicated that he was feeling a little uncomfortable and intimidated, and that was the note reflected that it was not just him, that there were other members of the jury who were also maybe feeling that uncomfortable sentiment from these people who were allegedly looking at them from the back of the courtroom. The court did all the,
Judge Blount addressed that issue head on.
yes, Your Honor. But that is part of the issue here, is that although some of the issue was referenced to the jury or to the court and to the parties outside of the presence of the jury, the court began by addressing this note with the jury present.
And he told the jury that the court security is very good and that the jurors had no reason to be concerned. He assured them, didn't he?
He did, Your Honor, but I believe that that was insufficient to kind of cure the prejudice here. There was no, the law requires that there be, if there's some sort of raising that there is maybe some external bias towards the jury, and trial counsel raises that as they did here and asked for some sort of inquiry, because Mr. Watkins' attorney did ask for the jury to be voir dire to see who, if, who had this effect on them, who was persuaded by that. All of this contributed to the fact that it may have had an effect on the overall jury and not just juror 6, and some sort of inquiry should have been done.
So what's the impact on your defendant? He was convicted because the jurors were intimidated?
There is, yes, Your Honor, that would cause
It
prejudice.
seems to me it would cut the other way. They would acquit him if they were intimidated, wouldn't they?
Not necessarily, Your Honor.
Okay.
That could also send a message to a jury that they should be scared of the defendant and the members of his family. And so that can cause a little bit of fear, and they may be inclined to believe that Mr. Taylor is someone who's dangerous, if there's someone that can be threatening him from his family, and so he is more likely to have committed the crime that
The
he's charged with.
defendant would be locked up, but the family would still be out there. And so they would be worried about the family retribution, wouldn't they, if they convicted the defendant?
Not necessarily, Your Honor, because the family members are, they could be worried about retribution from Mr. Taylor, from members of maybe other members of his family or loved ones, knowing that there are people in the back of the courtroom who are attending each day of trial whom they believe to be affiliated with either Mr. Taylor or Mr. Watkins, giving them these stares that are making them feel uncomfortable. At the very least, the trial court here should have followed either trial counsel's request. Either there should have been a voir dire of the jurors. This juror should have been made an alternate. However, the trial court merely said, hopefully this problem resolves itself. Hopefully, they'll have forgotten about it by the time that the trial is over, and let's proceed as such. And that's what happened. And as a result, we have an unfair trial here as a result of this juror's potential bias.
Okay. Any questions?
If this court has no other questions, I will.
Well, good argument.
Okay.
And you don't need rebuttal because there's nobody here. So,
Yes, that's
all
true.
right.
Thank you,
Thank you
Your
very
Honor.
much. Have a great day.
Thank you.
Yeah.
Have a good day.
Calling number 13 on our docket, case number 368-234, People versus Tyrone Carlise Demings.
Good morning.
Good morning, Ms. Somerville. I'm
Lee
sorry.
Somerville on behalf of Mr. Demings. Also, Mr. Byrd is present on behalf of Mr. Demings. We're consolidated, I guess.
Okay, so are you guys sharing time or what are you
We're
gonna,
gonna
oh,
sh-
excuse me, let me call the companion case. You're correct. Thank you. I'm calling companion case number 374-372, also People versus Tyrone Carlise Demings. I don't know how you guys want to divide up your time, but you don't necessarily both have to stand there, but I would say, or would like only one of you to address the court at a time.
Okay, so I'll go first.
Ladies first.
Or age before beauty, who knows?
But you are age and beauty.
Oh, thank you.
We'll all sign off on that.
I just wanted to make a few comments about the prosecutor's response, which just recently arrived. He essentially argues a lot of facts that are now acquitted conduct under Beck. And with respect to counsel not calling Philonda Scandrick or Romel Coggins, he, is arguing that, oh, there's all these witnesses that said this happened. But first of all, the whole thing was started with Philonda allegedly having a gun pointed at her. And we submitted an affidavit from her saying that, no gun was pointed at her. And she didn't think she'd spoken to defense counsel. She thought that a prosecutor was calling her for some reason. And the thing about Romel is the prosecutor refers to his affidavit. I don't believe there is an affidavit. I certainly didn't get one. I was relying on the Ginther hearing where Mr. Miller said that he appeared at court a couple of days and he said he didn't see any shooting. But then if you look at the prosecutor's brief, the second paragraph on page 13, he has a bunch of witnesses placing Romel right in the middle of the scene when the shooting is happening. Supposedly, my client is shooting from a couple houses away at this house or at the people. And although he wasn't convicted of shooting at people, he was convicted of shooting at the house and causing an injury. They have Romel in his car in the driveway. And a couple of people were talking to him. I think at least one of them was one of the victims of the acquitted conduct. So I think that that would be important to have somebody who is supposedly there in the middle of it saying, no, I didn't see a shooting, because it's my client's position that there was no shooting. With respect to the second sort of combined issue, I just thought they were related. The prosecutor arguing that he fled and went into hiding for 2 years. There was no testimony that he was in hiding for 2 years. He was out to brunch and got arrested 2 years later. We included his affidavit indicating he was living with relatives and he was working at some, restaurant on Plymouth, which sounds like a diner kind of thing where usually you can see the cooks from any place you're seated in the
Didn't
restaurant.
the judge give a curative instruction, Judge Van Houten?
Pardon?
Didn't Judge Van Houten give a curative instruction?
No, she gave the flight instruction. And it just seemed wrong because everybody was testifying how they were telling him to get out, get out, get out. And he had his bag packed and was waiting for this Romel to come get him. And then he left, which doesn't seem like flight. It seems like, I've been told to go and I'm going. And I did notice in the prosecutor's appendix 1, which is an older unpublished case, but on the second page, it cites a case that stands for the proposition that mere departure from a crime scene is insufficient to support a flight instruction. And I think that's all this was here. And even though the flight instruction says it's not necessarily proof of guilt, it does lend a bad connotation towards defendant that he fled because he did something bad.
But I think that Judge Reardon's point, the trial court did give the general, the normal instruction about lawyers' arguments and statements are not evidence,
Oh,
right? Because
Yeah.
that's all it was. Was it in the closing argument where he said he takes off?
yeah,
Which
it was.
Which was, you're right about that. I mean, there's no evidence he took off, but he was, didn't he go to Illinois or something like that? Or is that what I think?
No, different case.
That was a different case than what yesterday.
I mean, he drove away. He just
Yeah.
wasn't hiding.
Yeah.
Right. He left, but he was already been told to leave and he was just waiting for this guy to come get him. And he had his little bag packed, I guess, because that's what the testimony was.
He did take off, but I think there was a statement, he goes into hiding for about 2 years.
Yeah.
That wasn't supported, I don't think.
No,
Yeah.
there was no discussion about, we searched high and low for 2 years every day.
But it could have been trial strategy, don't you think, that the
I'm sorry.
trial strategy that defense counsel didn't bring the jury's attention to that?
Well, he did say at the Ginther hearing that he doesn't object during a closing argument. And I have noticed that it's mostly prosecutors that object during closing argument. But anyway, I don't think he's a bad lawyer. I think he did a great job. He got lots of not guilties here, but the last little thing could have been presenting those other two witnesses and objecting to this instruction to get a complete not guilty. And then Mr. Demings is serving a fairly long sentence, given the felony firearm second. So I think he has suffered a lot of prejudice in this case. So thank you. I'll leave it to Mr. Bird.
Okay, thank you.
Morning, Your Honors.
Morning.
Brandon Bird on behalf of Tyrone Demings. Your Honor, Your Honors, I believe the main issue that I see in this matter is that the trial court then resentenced de novo. Here, the trial court granted a resentencing. They formally removed multiple victim factual premises from the pre-sentence report and acknowledged that foundation that the original sentence record had changed. But when the court imposed the new sentence, it just reaffirmed his original proportionality reasoning without building the sentence from the corrected record. In other words, it was never reset. The factual foundation changed, but the sentence did not. Well, I should say the sentence did not. It was modified for a year, which he got a year for good time, being good behavior in the prison. But besides that, that's a modification. I believe that's a modification, and that's not really completely looking at the complete picture. The prosecutor's brief never confronts the sequence of the factual foundation and how the court uses original proportionality argument. It treats it kind of like an ordinary first sentencing. It argues at length about whether OV9 could be supported by the trial evidence and whether the court followed the mechanics of 6.425, but neither of those answer the actual question before this court. And that's once the trial court altered the factual narrative and ordered resentencing, did that resentence happen de novo? Or to put it in other terms, did it happen as it was in pre-sentence posture? Here is not that the court didn't hold a hearing. It's not that it didn't hold the mechanics. There is the court reaffirmed its original rationale after that factual foundation changed with the multiple victims. For that reason, Mr. Demings is not asking this court to impose a sentence. He's asking only that the sentence be vacated and remanded for a true, meaningful de novo resentencing. Before turning to the merits, I do want to address the standard of review. The people are correct that there was no contemporaneous objection at resentencing. So the court is reviewing these matters under plain error. And any ineffective assistance of counsel claim is limited to the existing record. But I do believe that sometimes what's missing in the record is part of the record. And we see that when Mr. Demings' counsel didn't bring up the OV9 situation, but the OV9 situation isn't the main focus of this argument. The main focus is the reviewing of his resentencing de novo after so many of the facts has changed, after we took out the multiple victims. The court acknowledged that the factual record had changed at the November 27, 2024 hearing. All but one alleged victim were removed from the pre-sentence report. The court accepted that revised pre-sentence report. The court accepted the sentencing narrative was no longer what it had been at the original sentencing, but the court still stated how it remembered the past sentencing, and it still feels that the 10 years is appropriate. And we don't have any analysis why that 10 years is appropriate. It didn't rebuild the sentence from a corrected foundation. It expressly anchored itself in the first sentencing. And that statement matters. When the court stated, I do recall the first sentencing and what happened, I still think 10 years is proportionate. That sentence matters because it shows the court didn't approach resentencing with a blank slate. And in order to approach the sentence with a blank slate and a pre-posture status, it must think about the new foundation that was laid with a lot less victims.
What statute, court rule, or case says that has to be done every time on a resentencing?
It was in the Rosenberg order, Your Honor. And
I don't think Rosenberg says what you think it says. But that's what you're relying on, those Rosenberg.
I am relying on Rosenberg, Your Honor. It was applied in People v. Davis, and I think it's kind of consistent with Triplett's requirement that resentencing be a meaningful new sentencing decision based on the current record. And I respectfully, Your Honor, the court did articulate the new proportionality analysis. It did, but it didn't reassess the offense in the light of the revised factual framework. And I believe that's really what we're dealing with here. The OV9 argument and the ineffective assistance of counsel argument, I believe that kind of shows the totality of the circumstances of why the court might not have approached it, because counsel didn't effectively correlate the multiple victims to the OV9 and to laying the new factual foundation or argument to analyze the a new rationale for why they might have gave the 10 years or why they shouldn't have gave the 10 years. But unfortunately, the court didn't do that. It just used the same rationale from that first sentencing. And that's not taking it for a pre-sentence posture.
Okay. Judge Berg, you have a follow-up?
Thank you.
Thank you, Mr. Berg.
Thank you. You all have a great day.
You too.
Too.
Take care.
All right.
It's going to get really cold today, I think. Both those cases are submitted. Calling number 14 on our docket, case number 370503, Courtney E. Morgan versus Jeffrey T. Myers.
Good morning, Your Honors. My name is Norman Ankers. I appear on behalf of Courtney Morgan, who is sitting with me at council table. With the court's permission, I'd like to reserve 5 minutes for rebuttal, although echoing Judge Warden's comments, I don't expect to spend anywhere near a half hour with respect to my argument.
That's very good news, Mr. Ankers.
Thank you, Your Honor. As the court knows, the trial court granted summary disposition here. In 3 particulars, we think that everyone was erroneous under the de novo standard and under the standards which govern summary disposition. Let me address them briefly in order of complexity. As the court knows, Mr. Morgan and Jeffrey Myers were associated in a firm, which was a PLC called Morgan and Myers. The lease to the premises of Morgan and Myers was up in July of 2019. Mr. Morgan asserted in connection with the proceedings before Judge Sullivan, which involved a complaint for dissolution and a counterclaim for dissolution, both of which have now been granted, that as part of the winding up of the business and the separation of the two, there was an agreement between Mr. Morgan and Mr. Myers that if Mr. Morgan vacated the premises, as he did by May 12, 2019, rather than waiting until the lease space for the firm expired in July, Mr. Myers would pick up the tail malpractice insurance policy. He submitted an affidavit to that effect. That affidavit was unrebutted. Judge Sullivan granted summary disposition and required Mr. Morgan to pay half the malpractice tail and didn't say anything about that affidavit. We think that affidavit creates an issue of fact, a clear issue of fact. Now, it may very well be that on remand, you'd have a half-day hearing. The judge would hear Mr. Morgan, Mr. Myers, look at whatever correspondence was associated with the agreement and conclude it didn't exist. But you can't do that on summary disposition. That's our simple point with respect to that first item. Second item, Mr. Morgan also testified and submitted an unrebutted affidavit with respect to certain expenses which had been incurred. As the court knows from having read the briefs, although they were a PLC, over a period of time, the relationship evolved so that each was responsible for their own expenses and their own profits. And one of the expenses is rent, and one of the expenses is copying expenses. And there was an agreement, as your honors know, which is part of the joint appendix, that was entered into in December of 2008, which said each of you is going to be responsible for expenses which are directly attributable to you. That wouldn't apply to things, for example, like the office receptionist, the person who answered the phone, because you can't separate that out. But you can separate it out because starting in 2008, they conducted their own cases. They had their own associates. They had one lease space, but a certain quantum of associates was dedicated exclusively to Mr. Myers. Another quantum was dedicated to Mr. Morgan. We submitted an affidavit saying, you know what, now that we've broken up, there should be some kind of reallocation here based upon the actual use, based upon those direct expenditures. Trial court ignored that. The only thing that the trial court cited was the fact that Mr. Dieters, who was the accountant who functioned as the CPA for the firm and for the two individuals for a period of time, had arbitrarily divided them 50-50. But as Mr. Morgan says in his affidavit, you know what? That was done for convenience's purposes, for the purpose of doing the tax returns, but there was always an understanding that there'd be a reconciliation at the end. Trial court completely ignores that affidavit and grants summary disposition and says, I'm not going to give you your allocable portion. I'm not going to divide it up so that Mr. Myers is responsible for his portion of the expenses and his portion of the lease space. That's a mistake.
You mean at the end of their partnership? You don't mean at the end of the year, correct?
Yeah, at the end of their partnership. That is correct, Your Honor.
All right, just checking.
So that's a second mistake that the court made. And once again, you could maybe have a half-day hearing with respect to this. The court hears the testimony, court makes a decision as to what's meant by direct expenses. Court looks at this issue, but you can't do that on summary disposition. The third and the most complex issue, of course, is this issue with respect to the no poaching that took place. And we think that there was a tribal issue of fact with respect to that question, because Mr. Morgan testified at deposition, there was a no poaching understanding. In addition to testifying that at deposition, he said that in an affidavit. In addition to saying that in an affidavit, he also cited in his deposition that there was an earlier point in time where Mr. Myers had, an associate of Mr. Myers, had stepped on a relationship that had been brought, a referral relationship that belonged to Mr. Morgan in the first instance, and the associate was told not to do it. All of those things create an issue. Now, you can stroke it as breach of fiduciary duty, which I want to talk about in a second, breach of contract, promissory estoppel. The judge rejected all of those. But here's the basic guts of the argument. These two were part of a PLC. That meant that they had certain obligations to clients as a firm. For example, under MRPC 5.1, if God forbid Mr. Myers or Mr. Morgan should see that there was some ethical violation which was taking place, he would have an obligation to take remedial action. If one of them got sick, the other one would have to step in. That obligation to clients morphs into a relationship that the two have with one another and duties that they have to one another. Whatever the contours of the obligation to be a fiduciary and fiduciary duty, and we know from the recent pronouncement of the Michigan Supreme Court with respect to this issue that it involves good faith, loyalty, and care, that is surely breached if you have, as was the case with Mr. Morgan, getting a referral from Fritz Dam.
Wasn't there, this hinges upon what's a referral source, isn't it? What did they mean by referral source?
What they meant was the person who had suggested that that this person be employed to do the work on the case. And in our case, Fritz Dam had just had a case with Mr. Morgan.
The referral, excuse me, Mr. Ackers.
Yes.
The referral source is the attorney, or is it the person bringing the referral?
It is the attorney. The attorney would be the referral source, because what he said was, I have this good friend and client, Sue Vincent, who is a family friend. That's how it happened.
When I was reading that, I thought, well, referral source could be, there's somebody at the union hall that's sending cases.
No, that's what the referral source is. Whatever the scope of fiduciary obligation is, Your Honor, it is surely violated when, as we know happened here, Mr. Myers finds out about this potential for a business, has a surreptitious meeting with Sue Vincent, who is the person the dam was going to refer, and we believe
They were all law school classmates or something.
they were moot court partners at Wayne Law School. That is correct.
Let me ask you,
Yes.
was the term referral source ever reduced to writing what it meant?
It was never reduced to writing, Your Honor, but under 450.4202, the only thing that has to be in writing is the articles of organization. And the Supreme, strike that in this court, in the McInerney case, among others, has specifically upheld oral agreements. Once again, the question is, was there such an understanding or not? You can't decide that issue on summary disposition. And that's the mistake that was made in this case. And whatever the source and the contours of fiduciary duty are, if it's really true that there was a surreptitious meeting, which Sue Vincent testified about, that Myers brought, and
I remember a meeting, but what made it certificate?
Mr. Morgan didn't know about it. He found out about it after the fact. And when he confronted Mr. Myers about it and said, hey, we have this referral relationship, Mr. Myers said in words or in substance, payback's a bitch, referring to
Life. Go ahead.
yeah, referring to we have something that had happened with Sam Bernstein, as we explained to the court, that was unintentional because he didn't know that he was a referral source. There's no doubt in this record that there was a referral source relationship which Mr. Myers knew about. If that happened, and we believe it's also possible that during this meeting, Mr. Myers told Ms. Vincent, Mr. Morgan's retiring. We think that might well have been the inducement. I asked her that question at deposition, and she said, I don't remember one way or the other whether or not I said that. But if you make a misstatement for the purpose of getting that business, that's a violation of fiduciary duty. It's also a breach of the agreement that Mr. Morgan has attested that the two of them had. Now, by the way, that issue is completely different from the issue of who the client gets to select. The client can select whomever the client wants, but that doesn't mean that there might not be a cause of action for breach of the referral relationship. Let me give you an extreme example. Let's suppose you have two solo practitioners who are in a building next to one another, and one unscrupulous solo practitioner notices that there is somebody who keeps on coming over to the other lawyer's office. And the unscrupulous lawyer gets a sniff that that this is a potential client. So he breaks in my extreme example, he breaks into the office, finds a file, sees that all of the spade work has been done by this lawyer whose office is broken into, and then contacts the person the next day and says, I'll give you a better deal than he gave you. Hire me instead. And he hires them. The client can still make the choice, but that doesn't mean that there isn't a cause of action for the wrongful conduct which took place. And I would argue that in this case, because they were part of a firm and because they had reciprocal duties to clients, and reciprocal duties to one another, the breach here, whether it's you call it fiduciary duty or breach of an agreement, is even more egregious. The only response which we got from the trial court to that issue was, well, you only owe a fiduciary duty to the PLC. You don't owe it to the other person who's a member. That can't be true in this case when you've got a 50-50 membership of a PLC, because if that were the rule, anytime one of the two 50-50 members engaged in bad behavior, you wouldn't have a cause of action because it would belong to the PLC and you'd never get the requisite vote. And that's exactly why Fasihi versus Summers Schwartz says in the close corporation context or close membership context, you have duties to one another. Once again, it was up to the trial court to decide, if you have a hearing, you can decide whether you believe this stuff. Was there an agreement? What were the contours of the agreement? What was it violated? But you can't decide that on summary disposition.
I suppose I can go back and look at this myself, but they were both considered general partners as opposed to one running the firm and the other being a limited partner.
That is correct.
Okay.
That is correct.
Just so I can take another look, can you give me that side again, please?
Oh, Fasihi, Fassihi versus Summers Schwartz. And that's a Michigan Court of Appeals case. And I believe that it's 107 Michigan 509, but my memory's not as good as it was 46 years ago when I started. So, but it is a relatively recent Michigan Court of Appeals case.
I don't believe that. I think your memory is probably just as.
Right.
It is on the important stuff.
Yeah. So that's all that I have, Your Honor, unless the court has any questions for me.
You have plenty of time for rebuttal.
Thank you.
All right, thank you.
Good morning, Your Honors. May it please the court. My name is Bert Ross and I represent Jeffrey Myers in this case. I'll address these issues as Mr. Ankers did, sort of in backwards. Going back to this fiduciary duty claim, Mr. Ankers fails to point out that his first complaint that he was filed, in fact, had a breach of fiduciary duty claim between the partners. And in which time we file a motion saying, no, the fiduciary duties are to the PLC, not that the individual members don't owe each other fiduciary duties. Before that motion was heard, Mr. Ankers filed an amended complaint changing the allegations so that it was now alleging fiduciary duties owed to the PLC. And with respect to the whole PLC issue, I would point out that they were practicing in form only as far as a PLC. The actual facts of what they were doing was they were sharing space. They each had their own practice. They were competing. They had their own associates. They had their own secretaries. They did share a receptionist. They shared the copying and these other office expenses. But it was a space sharing, and for whatever reason, they did have it in the form of a PLC.
Sorry to jump. I was thinking about something counsel said, and I was just in the final wrap up, that piece, didn't that go to like an arbitration or a mediator or something, and a number came out and there was some credit given for the fact that he had already moved out of the office and wasn't in the state.
Those were addressed. That was a separate little issue about moving expenses.
Did that include the secretary though, and some of those other ancillary?
No, it did.
Being in the office.
It didn't include the office space, the costs. It was other claims that he had. It did include a computer which had been purchased that stayed with Myers that Morgan claimed he was entitled to some credit for because he paid for a portion of that sort of thing. The dissolution, all of Morgan's claims were done by the end of 2018. At that point, all that was left was Morgan's counterclaim for dissolution, which was a simple counterclaim. There's a deadlock. That's grounds for dissolution. And at the hearing on that, Mr. Ankers stipulated that, yes, we can dissolve the PLC, and then we'll reserve the right to argue about how the remaining materials were divvied up because they were still in the space. They still had bank accounts. They had IOLTA accounts. They had these client trust accounts where big funds were put into as opposed to the IOLTA account and commingled. Those were all the claims that went to arbitration. So at the point where all of Morgan's claims are gone, we've got this dissolution pending. We make a motion for dissolution. Judge Sullivan says, try to work it out. The parties tried umpteen which ways to work it out. By the early 19, we get into that tail policy because at the time of dissolution, and I want to speak to that tail policy issue because there was no question of fact about that based upon Morgan's affidavit. He hasn't, when they had a date in February that they were going to be out of, that they were going to be officially dissolved. They each had to go obtain their own malpractice insurance. As a condition of that, there had to be a tail policy to cover the previous grounds of that. Myers, through his attorney, had proposed that, as it turns out, that they could get a better deal on that tail policy if one or the other was named a successor firm. And so Russ Etheridge, Mr. Myers' attorney, talked to Mr. Ankers and said, if Myers will take over the space and will agree to be the successor firm if Morgan will agree to move up in 60 days. Mr. Ankers came back and said, no, 90 days, but it was all about whether there would be a successor firm. And that is the contemporaneous correspondence between the attorneys at the same time. Mr. Morgan is putting in his affidavit, there was some agreement that he would move out if Myers would pay the premium. There was nothing in that writing about the premium. It was only whether one of them would agree to be the successor firm. That didn't happen. So they ended up without that discount of anybody being a successor firm. The firm ended up paying, we had to go back to court to get a court order that the premium, the tail policy premium be paid out of the firm bank account, which was still in existence. And that was paid, and now we're arguing about it. Later, Judge Sullivan on our summary disposition motion said, no, that was should be shared. There was no agreement of this, of this moving out thing. And it was all, they always shared the insurance premiums for the firms of malpractice insurance equally, even if one side had more attorneys than the other. It was never based upon exposure or any of that. It was always split. And so Judge Sullivan said the practice was to always split it. We'll split the tail policy. And that was his ruling on that. And likewise with the rent and the copying costs, which were the only other dissolution issues decided by Judge Sullivan. He decided that copying costs had always been split. Therefore they should be split. And the same with the rent, regardless of how much space any particular individual was done. That's how it was always done. And that's how it should be upon the dissolution. In response to that, Morgan, all he has is this affidavit saying that, that was just the accountant or the bookkeeper's convenience that he did it each year. I mean, this is for preparation of the financial statements, for preparation of the tax returns. These are the final numbers that they're agreeing to. But Morgan comes in and says, no, if and when we ever dissolved, we were going to revisit all of that. But here we are again, 10 years into the PLC, and they're talking about copying costs going back to 2008, 2007. I mean, how is that going to work? Are they going to go back and redo all of the tax returns for that decade? It was just incredible for him to say that that was just a convenience, and we agreed that there was going to be revisited upon
Isn't that
dissolution.
the anchor's point? That's a question that can't be resolved on summary disposition.
Not when it's not when there's no evidence of that. I mean, not
Well,
when it's
evidence is-
contradicted by the whole practice of what they've done all these years.
Evidence is his testimony too, though, isn't it? I mean, it doesn't have to be documentary evidence. It can be I think his deposition testimony, I can't remember what his affidavit was like. The deposition testimony, I don't think was really a clear statement of an agreement. It just was
I think it was an
explanation of what he thought was a past practice. But again, yeah, every year they did this 50-50 split, but one of the partners says, well, that was just what we did, but our agreement was, his argument. And why isn't that something that has to be resolved by Judge Sullivan getting up in there and saying, I don't believe a word you're saying because of your past practice? You know what I mean? That's what I'm trying to grapple with. Is why it's not a question of fact.
Well, it's not a question of fact because of what they did. At some point, the judge, and this is a bench trial, this is going to be a bench trial if it were to ever be tried. At some point, he's got to look at what the actual practice was and the merit
I
and
agree with that.
the vagueness of this statement. And I think it wasn't an affidavit, that it was just this vague statement in an affidavit. But
Okay.
so, and that's true of the rent and the copying. And finally, there's the whole issue that started the case, these two cases, the Al-Jabi and Sue Vincent's case, the Williams case. As the court has already indicated, who is the referring attorney? And was that even if the Judge Sullivan gave credit, he said, the parties probably did as a practice respect their respective referral sources. But what is a referral source? Both of these cases came from somebody that had no previous experience with Morgan, had never referred a case to Morgan. Sue Vincent was a longtime acquaintance from law school with Mr. Myers. Jennifer Englehart was an acquaintance of Mr. Myers, and the firm that she was then working for was also a referral source to Mr. Myers. All of
We're
those,
using a different definition of referral source than what Mr. Ankers was using.
yes. So for example, in the Williams case, the Williams has a friend who's an attorney, Sue Vincent. They say, can you help us get an attorney? She is the referral source. She goes out and asks her colleagues, do you know anybody that you could recommend? One of them, Britt Stam, says, I'll recommend Courtney. But
I thought referral source was the attorney who the case was intended to be sent to.
no, the referral source is where the case comes from.
Okay, I think you and Mr. Ankers disagree on that.
I guess so, if that's what he's talking about. Because as I understand the referral source, the attorney that refers the case in typically gets
If
a
I
third
refer
of
a
a
case
third.
to you, I'm the referral source.
That's what I'd ask.
Right.
Yeah.
That's what I asked Mr. Ankers about, like a union hall referral source, something like
Mhm.
that. And he seems to, Mr. Ankers can clear this up. He said, I thought he said, no, it was to whom the case was intended to go.
Right.
That's the referral source of the firm.
Well, okay, he and I have a different terminology on that then. Because respecting referral sources, again, these cases were never going to go to Mr. Morgan. They came from Jennifer Englehart, was a referral source typically who referred cases to Mr. Myers and did it in this case. It just happened to land because she also knew Mr. Bowling, but as she explains in detail in her affidavit, had no knowledge that Mr. Bowling worked for Mr. Morgan as opposed to Mr. Myers, and that they had separate associates. She assumed that any associate of the firm worked for Myers. And with Sue Vincent, she being the referring attorney, she said that she hadn't initially thought of Myers, but once he was in the mix, she said he was the one that I thought, and still, she still had the family interview another attorney along with Mr. Myers, and they made the decision based upon their reaction to those attorneys as well as the fee arrangements that those firms, Mr. Myers and the other firm, were willing to make. So, does the court have any other questions about this factually or?
No, thank you. Just looking up something.
You want us to wait?
No, I'm not.
Okay, thank you very much, Mr. Ross.
Very briefly, Judge Maldonado, you had asked about the arbitration that took place before Keith Brooks. That did not involve the rent expenses or the copying expenses because those had already been excluded from the arbitrator's consideration by Judge Sullivan's ruling. So rent and copying expenses were not part of that. And that's where we think there was a tribal issue for all the reasons I described. Secondly, counsel says that the supposed agreement with respect to the rent and the expenses was vague and not specific, and that the testimony and the evidence that would be brought to bear was not specific. Here's what Mr. Morgan said in paragraph 2 of his affidavit. When Mr. Myers and I had the Morgan and Myers bookkeeper split expenses, such as rent and copying expenses at year end, this was done for purposes of convenience in order to allow the books to be closed for a given tax year. There was never any understanding between Mr. Myers and me that these expenses would or could not be reallocated in accordance with the proportion in which they were incurred by the two of us in the event of a dissolution of Morgan and Myers or for any other reason. To the contrary, we made a number of agreements, including a written agreement effective January 1, 2009, that each member of Morgan and Myers would be personally and exclusively responsible for all expenses directly attributed to him. This included allocable net expenses and copying expenses. That's pretty clear. There's nothing vague about that. Again, court might choose to disregard that, but that's not the appropriate subject of summary disposition. Finally, on the referral issue, Mr. Dam's the referring attorney. He said, I've got this person, Sue Vincent. Sue Vincent said she wanted the best lawyer that there was. Mr. Dam unconditionally recommends Mr. Morgan, says he's a person of high integrity. He had just settled a Washtenaw County case, which is where Ms. Vincent's family friend had been killed. He had settled it for 8 figures. This was the perfect person to do it. Then you have a surreptitious meeting in which we believe he falsely tells Ms. Vincent that Mr. Morgan was retiring from the practice, and after that, the family ends up hiring Mr. Myers. That issue is a tribal issue of fact as to exactly what happened there.
But can I just ask, unrelated to any of the marriage?
Sure.
This is a 2017 case. And it's 2026.
Yes.
How's it possible that this is still lingering around on this stuff?
It sat around in front of Judge Sullivan for a very, very long period of time, Your Honor. And that wasn't the fault of Mr. Morgan or me.
I'm not
We didn't ask
casting
for
it.
it.
I wasn't looking to cast blame. I was just curious. It was a civil case, and
Yeah,
lawyers
it's-
are involved on all aspects, and it's almost 10. I mean, it's 9 years later.
It's been a very long time, and the briefs in this matter were filed in 2024. But I appreciate that
Yeah.
this court is extremely busy too.
Yeah.
But
Right.
but we think that we could still bring that stuff to bear.
Well, sure. It was just a curiosity. That's
Yes, of course.
Yeah.
Thank you, Your Honors.
Well, thank you very much. Well argued. Case is submitted. That's right, you're sticking around.
I'm back like a bad thing.
Calling case number 15 on our docket, 370-561 Green Skies Healing Tree LLC versus Green Peak Industries Incorporated.
Thank you, Your Honor. Norman Akers appearing on behalf of appellants.
Welcome again.
Once again, I'd like to reserve 5 minutes for rebuttal, but once again, I would be highly surprised if I am going to come anywhere close to the half hour of argument, because I know how assiduously the court has read these.
Once again, the court is very pleased today. Thank you.
As this court knows, there are 2 issues for this court to decide in connection with this appeal, and I will address them in turn. The first is whether the Canadian, what I'll call the Canadian defendants as a collectivity, should have been dismissed from this litigation for lack of personal jurisdiction. And then the second question is whether, as to the individual defendants, the Michigan residents who did not file a motion to dismiss for lack of personal jurisdiction, Judge Warren erred in saying that these claims should have been brought in the Ingham County Circuit Court as opposed to the Oakland County Circuit Court. So I will address those 2.
The receivership.
Yeah, yes, where the receivership is pending. So I will address those 2 in turn. First, on the subject of whether or not Judge Warren made a mistake in concluding that there was a lack of personal jurisdiction over the Canadian defendants. The Canadian defendants include an entity called Tropics LLP, which was a wholly owned subsidiary of Sunstream, the joint venture between SNDL and SAF Group. Tropics filed a lawsuit in Ingham County Circuit Court saying it was authorized to do business in the state of Michigan, and it sued GPI, also known as SkyMint. So it has been, by voluntary choice, in the Ingham County Circuit Court. How in the world could Judge Warren have concluded that there's no personal jurisdiction over a company which chose voluntarily to bring a lawsuit against the debtor GPI when what we're alleging alleges out of that same fundamental transaction or occurrence? In fact, we say in paragraph 87 of our second amended complaint filed in the Oakland County Circuit Court Tropics intentionally and wrongfully induced GPI to close on the amended and restated APA between the parties, that's my clients and GPI, for the purpose of obtaining more collateral to support its loan. Tropics knew that the GPI stock was worthless and the liquidation preference was meaningless because, as Tropics has admitted in writing, the loan was in default as of March 2022. That's right in the receivership complaint, which was filed in Ingham Circuit by Tropics. Once again, Your Honors, the trial court might conclude that Tropics didn't do anything that was wrongful, really didn't think that the stock was worthless, really didn't induce the entering into by GPI of the amended and restated APA, but that's for the trial court to decide, and the court clearly has personal jurisdiction here. There's another issue. In our second amended complaint, we talk specifically about the connections with Sunstream, which is the joint venture involving SNDL, Sundial, and SAF Group had with Tropics and its connection with this transaction. And we talk specifically about how they directed the entering into of this amended APA. And basically they said to the GPI folks, whom they controlled, they loaned $80 million to them, listen, we got to make this look like a good deal to us because it affects our bottom line. Say anything you want, do anything you want, just get them to execute that amended APA because they are going to transfer extremely valuable assets as part of this process. That's right in our complaint. Under the Mitchell case, which we've cited, Anderson Mitchell, 448 Mich 178 at 194, that statement is in and of itself enough to establish a prima facie case that there is personal jurisdiction. The court did not conduct an evidentiary hearing here. That recitation is enough, supported by the affidavit of Mitchell Berukowitz, to establish a prima facie case of personal jurisdiction over these defendants. Again, if they want to argue about it later, if they want to argue factually about what it was that happened, they can do so. But the court will note that the affidavits that were submitted by the Canadian defendants are as significant for what they don't say as for what they do say. You have two recitations in there. One's from Zachary George, and he talks about Sundial, and he says, Sundial doesn't own any property in the state of Michigan. And then you have something from Mr. Dunfield, who speaks on behalf of Tropics, who says, we don't own any property in the state of Michigan. They don't deny what we said in our second amended complaint, which is they directed tortious conduct toward the state of Michigan, toward our client, which is a Michigan company, for the purpose of grabbing those assets. That's enough under MCL 600.715 to establish personal jurisdiction over these defendants.
The case that is in Ingham Circuit Court, you said Tropics filed it?
Yes.
Okay. What if someone was thinking that this Oakland case belonged in Ingham because of it's under the receivership statute, and it was sent over there?
Yes.
Then wouldn't you have a even better argument on personal jurisdiction if you're in front of the judge where the company is the plaintiff?
No, I don't think the argument is analytically better, Judge Breed. I'll tell you why.
I mean, not analytically, but I
Yeah.
mean, it'd be slapping the judge right in the face that
Yeah. No,
that's the party, that's a plaintiff.
understood. And I understand that.
Yeah.
That might have brought it more front center to
Right,
the Ingham
right.
County Circuit Court judge. I agree with Your Honor with
Yeah.
respect to that. But analytically, whether or not there's a connection with Oakland County, which is where our businesses are, depend upon whether the tortious conduct affected an Oakland County business.
I understand.
Yeah, and as the court knows, 600.715 says you get limited personal jurisdiction if you have the doing or causing of any act to be done or consequences to occur in the state resulting in an action for tort. And that's exactly what we have here. And there are all sorts of cases that are out there which we cite both in the state system. I mentioned the Anderson Mitchell case. There's a very famous one in the federal system which follows the same thing. I think it's Butaka versus Osama bin Laden, which is 417 F 3rd 1. You the cases say you don't have to actually be physically present in the state of Michigan in order, or the jurisdiction where somebody claims there's personal jurisdiction, in order for there to be jurisdiction. You don't have to own property or have employees. If you engage in intentional tortious conduct, which is directed toward the forum, that's enough. That's the Quickstar case, which we cite in our brief. And we think that that case is controlling. And then simply to segue into what Judge Murray said about Ingham County Circuit Court, the question was for the individual defendants, should it have been brought in the Oakland County Circuit Court in the first place, or is it related to the receivership action in a way which makes it appropriate for it to be in Ingham County Circuit Court? That's the second part of the argument that we briefed. What's interesting is your honors know from having read the briefs, the first 3 times Judge Warren looked at this issue, he said, correctly, I think, no, this doesn't belong in Ingham Circuit. This isn't related to the receivership action. It's a fundamentally different kind of complaint because the receivership in.
Yeah, but we understand that. But then what happened after that, after the third time that changed Judge Warren's mind? It was what one of your clients said in the other case, that you ought to stay until we deal with Oakland County because of the money and what's available and all that. And so he said, yeah, you know what? You're admitting now that it is related. So go over to Ingham County.
But it's
That did seem to like shift the judge's
Yeah.
mind.
yeah, but it's not related, Your Honor, and it's not related because as Judge Warren correctly found the first time around, the fundamental thrust of it is different. The fundamental thrust of the Oakland County lawsuit is you defendants wrongfully induced me to enter into
But
this.
it's not about the facts. It's about what are the assets that are in play over there. And that's what gives the receivership jurisdiction. It's the assets involved. So when the motion was filed requesting, that disposition of those assets be held until the completion of the case, that to me seems like the reason that the judge changed his mind.
The effect of the Oakland County lawsuit would not be to take a penny out of the receivership estate, and that's why it's not related, because it is a lawsuit that is brought against the individuals and companies who engaged in wrongful conduct, inducing the execution of the amended APA. If this were a claim against receivership property, then the result would agree with you would be different.
Well, what was the point of the motion then in that count, in the receivership?
Which motion, Your Honor?
The motion to freeze certain assets from disposition until the other case had been completed.
This was the reason for it, and it's a different reason.
Well, you know what, if it's not in the record, maybe I shouldn't have asked.
No, the reason for that motion to freeze is that there are also claims which my clients believe that they have against the receivership estate, against the very party which entered into the transaction with them, but we can't bring that action directly because under the receivership order, until further order of the court, you can't sue the entity which is in the receivership. So all they asked for by way of preliminary relief is, listen, before this stuff gets dissipated, we may have a claim somewhere up the road. This receivership is going to end. Maybe it was improvidently granted. That's the reason why a motion to freeze was filed. That doesn't affect the issue of whether the claims against the individuals that and the corporations that we've brought are different kinds of claims not related to the receivership estate. As we've said in our brief, all of the cases, the probate court cases, which the trial court cited for the proposition that they were related, were cases involving a much more definitive connection between the probate court. One was a lawsuit that claimed specifically that certain assets should have been brought into the probate court estate. Clearly, that's something which is related to the probate estate. There was a case which we cite in our brief where the lawsuit that was filed was a lawsuit brought against a person who was responsible for handling the estate of somebody for intentional infliction of emotional distress by engaging in all sorts of wrongful conduct in connection with that estate administration. The Court of Appeals, Your Honors, held in that case that isn't related to the probate court. And we think that that's controlling here. That's all I have on these two issues unless the courts have any questions for it.
You have rebuttal time.
Good morning, Your Honors. Mike Almassian on behalf of the appellees, Jeff Radway, Jeff Donahue, Al Gever, Matt Gavigan, and Jeff Jacobs. My clients' issues before the court today relate exclusively to question number 3 of the 4 issues presented by this appeal related to the exclusive jurisdiction question of the Receivership Act and the appropriate forum for the claims that have been brought against my clients. And I want to touch on just 2 topics. One, I want to talk about a policy issue that I would like to emphasize more than I did in our briefing. And secondly, I would like to reemphasize one of the exhibits to my brief. And I'm going to limit my oral argument to those 2 topics unless the court has further questions for me.
Yeah, I have a question.
Sure.
Before you jump into that, just kind of a following up on, yeah, when I was reading this, I was trying to understand like why they were trying so hard to stay in Oakland. And then I was thinking, well, perhaps they need that because they can't get in line with the receiver until they have a judgment of something, right? So how do they get in line for the receiver if they don't have some kind of monetary judgment?
Well, Your Honor, I think that question highlights a point that opposing counsel was trying to answer as well, and that is the claims against my clients are individual claims. Okay, these are brought exclusively against the individuals, not against the assets of the receivership estate, with one exception. And that is there's a D&O policy that is a policy that we contend is a receivership asset. And to the extent there is liability here, that policy would pay. And more importantly, it is a limits eroding policy such that the initiation of the lawsuit against my clients and the defense fees that began to mount from the day that complaint was filed began to erode the available limits under that policy, which we think clearly impacts the receivership property. That policy is clearly by the order property of the estate. And so to answer your question, Your Honor, no, they don't need to get a judgment against the individuals in Oakland County in order to get in line because the receivership is administering claims against the receivership assets. That answer your question?
Yeah, it does.
Okay.
Thank you.
So I would like to focus on the policy issue to begin with. This is a broad and expansive jurisdictional statute, and it's important to consolidate all aspects of a receivership into the court administering that receivership. The purpose, the policy, the intent of the legislature in doing that is so the court that is appointing the receiver could have the flexibility to administer finality and certainty in bringing an insolvent batch of assets to a conclusion. And so what I would like to reflect on is the statute not only specifically provides very broad and expansive jurisdictional language that is so expansive, it determines that the appointing court should resolve any controversy related to the receivership. It doesn't focus on party. And more importantly, to Mr. Anker's point, it doesn't focus on remedy. And I'll get to that in a minute. The other thing I want to focus on in the statute and that I want to highlight from a policy point of view is the statute also contains a stay of proceedings. And I think that really emphasizes the legislature's intent in what they were intending with the Receivership Act. Not only do all matters, all controversies need to get adjudicated in front of the appointing court, but the legislature saw fit under MCL 554.1024 to stay all other proceedings. They thought it was so important that an administering court deliver finality of all claims, that they consolidate all of them together and stay everything else so that all of the parties can come forward, whether or not it is an administration of the receivership assets or it relates to the receivership assets. And I think that highlights the intention of the expansive scope of this jurisdictional statute.
Well, it would have been so nice for the record if the judge would have, the receiver tried to intervene in the proceedings, correct?
Correct, Your Honor.
It would have been so nice to have, if that had been allowed, we had that on the record.
Well, we do have, as a part of the record, the transcript from the appointing judge, Judge Joyce Drangenchuk from the Ingham County Circuit Court, who did look at this and who did see the Oakland County Circuit Court complaint and said, I think that dispute belongs here. So she's on the record. She obviously couldn't overrule the court. This is the appropriate mechanism for determining in the Oakland County Circuit Court's point of view what is the appropriate forum. And Judge Warren eventually came around. And I think the court's point is correct. We are looking exclusively at the dismissal of the second amended complaint, not any other orders. I didn't appeal any of those other orders that found in a converse way. We're here on the dismissal order. And this highlights the last point that I want to reinforce. And I want to turn the court's attention and put a little bit more emphasis on it than I did in my briefing. And what I'm talking about is Exhibit 10. And this is the motion for reconsideration that was filed by these appellants in the Ingham County receivership action. It was done by separate counsel, wasn't done by Foley and Lardner, but it's the same appellants. And I want to underscore a couple of things that exist in that exhibit.
Talking about appellate's Exhibit 10?
No, this is Appellee's Exhibit 10, and the pages that I'm citing from are record IA 000941 and 942. And although Judge Warren cited this document, he didn't pull out a couple of other statements that I think are very instructive, and more importantly, are revealing as an acknowledgement from the appellants about what their real purpose is here and what the relationship is between the Ingham County receivership and the remedy that ultimately they're after here. And what they say is, quote, the Oakland County lawsuit asserts claims of fraud in the inducement involving Skymint. Involving Skymint, they say. That is the receivership debtor. They go on to say, given the serious and substantial claims made in the Oakland County case, and which asserts that the entire transaction between Skymint and Tropics were based on concealing information from 315, this court should pause any sale until the claims in Oakland County are adjudicated on their merits rather than approve a transaction that is the fruit of a poisoned transaction. And what they're really getting at here is, although in Oakland County, they say they seek a remedy related to a recovery against the individual defendants, if there is a finding that the transfer of the assets into the receivership estate was accomplished by fraud in the inducement, the exact facts that they are trying to assert in Oakland County, that will have catastrophic consequences to the receivership estate. And you can bet if there's a factual determination in Oakland County of inducement that invalidates that contract, of course you can bet they're going to go into Ingham County and upend that receivership, because then the receiver sale will have transferred assets in the receiver's hands that he had no business transferring. And that reveals the intent of their motion in the Ingham County Circuit Court and what factual assertions they're trying to reach in Oakland County in order to lever them together. And I think that's why Judge Warren got this correct. I think this case needs to be over in Ingham County. And the last thing I'll say, I don't know that it's relevant, but this case is proceeding in Ingham County. The plaintiffs did file a lawsuit against all of my clients for the same claims in Ingham County in front of the judge administering the receivership estate. So it's somewhat puzzling why we're here today, given that discovery closes on that trial court action that's currently pending against my clients. Thank you.
Even though you represent the individuals, the receivership argument would apply to everybody in the Oakland case, all defendants.
It would apply to all defendants, Your Honor, because it relates to, it has nothing to do with the parties.
Right.
It's the assets and how it may impact the
I just want to
receivership.
confirm that's what you thought.
That's correct, Your Honor. Thank you.
Rankers?
Yes, only very briefly. Judge Dragonchuk's position about this has been a little bit back and forth because when the receiver filed a motion in the Ingham County Circuit Court seeking to stay the Oakland County action, Judge Dragonchuk said, and we cited in our brief, I am not going to interfere with that. That is a separate cause of action. So you simply need to decide as a court whether or not this one better belongs in Oakland County or better belongs in Ingham Circuit.
Well, we'll do our best.
Thank you.
Thank you, Your Honor.
Thank you. The
Thank you.
case is submitted. Have a good day. I think you're done for the day here at least.
Now I have to teach 2 classes at U of M Law School, so it's going to be a big day.
Oh, my goodness.
Go you.
What do you teach?
So this semester, so I teach 4 courses in more or less combination. Conflict of laws. So if anybody ever wants to know about the Wanvar depassage, I'm the guy. And I teach trial advocacy. I'm teaching 2, we culminate with a jury trial with 20 people. I divide into teams of 10. We have a mock jury. We deliberate the verdict. I also teach electronic and class action discovery. And they've just asked me to start teaching evidence starting in the fall 2026.
How are you gonna have time to
Congratulations.
practice if you do all that?
I don't know.
Do you live out in Ann Arbor or?
Yeah, I go up there. Yeah, it's the only place where they have campus. So
I know. Do you live out in Ann Arbor? Do you
no,
live-
no, I live in Beverly Hills. So
Well, safe travels. There's bad weather coming.
yeah,
in.
okay,
All
thank you.
right, take care. Case is submitted. All right, calling case number 16-373-896, Michigan Pain Management versus Progressive Marathon Insurance. I think we have someone remotely.
Good morning, Your Honors. Matthew Payne appearing on behalf of the plaintiff appellants. I'll be very quick, or as quick as I can. I'm going to start with the partial dismissal regarding the Nervomatrix device. I have just 2 points to make outside my brief on this issue. The first is a procedural request that this court carefully parse out the facts and law when it issues its opinion. Factually, the evidence proffered in this case is over a year old at this point, and admittedly wasn't a comprehensive review of all the studies that existed even at that time. There have been and will be new publications regarding the Nervomatrix device, so the ruling here wouldn't necessarily apply to other cases even on the same issue, because it's sort of a limited temporal snapshot of the research at the time the issue arose in this particular case. And then legally, the parties agree the seminal case regarding reasonable necessity in the PIP context is Crone versus homeowners. While the issue in the trial court and on appeal here is limited to objective evidence of efficacy, that's only one avenue to meeting this element at trial. The Supreme Court also instructed in Crone that treatment is presumed to be reasonably necessary where it is generally accepted in the medical community as appropriate treatment for a particular diagnosis. I have not argued in this case at the trial court or on appeal that the Nervomatrix meets that requirement to create a rebuttable presumption, meaning that that issue isn't on appeal. And I think it's an important distinction because of the ongoing research and increasing use of the device to make. My second point is just a simpler explanation of the substance of my argument that doesn't really jump out of the brief the way that I would like it to. Now, there's no dispute that transcutaneous electrical stimulation, colloquially referred to as TENS as an acronym, is compensable as an allowable expense under the No Fault Act. This is a small box device with electrical leads that are stuck to the body, and it provides essentially the same treatment that the NervoMatrix device provides. The only differences between the TENS unit that we all agree is compensable and the NervoMatrix device are the method of delivery, specifically being the trigger point impedance imaging or TPII, and that it uses interferential current that reaches deeper into tissue. Not only is there evidence of efficacy as to the NervoMatrix generally as an entire machine, I also attached and included to my response in the trial court and on appeal here separate evidence of the use of TPII specifically and the use of interferential current specifically. So basically, the whole device has objective evidence of efficacy. And the only differences with treatment that everybody agrees is compensable are two distinctions with how that treatment is provided. Both of those distinctly have their own evidence of efficacy as well. If there aren't any questions on NervoMatrix, I'll move into the policy cancellation.
I think that's your bigger issue.
Okay, so moving on to that, I do want to clarify that I never ignored the spreadsheet the defendant created and attached to its motion in the trial court, which is what their position was on appeal here. My position is simply that this document does not constitute proof of mailing, both because it's hearsay as to the truth that any mailing even occurred, but even ignoring that, words typed into a spreadsheet don't constitute proof of mailing, regardless of the fact that that information is hearsay. Even the affidavit that was proffered in support that the cancellation notice was mailed doesn't actually support that proposition. This individual doesn't claim to have personal knowledge. She certainly didn't say that she mailed it. So it's hearsay for her to even comment on whether it was mailed at all. I also want to stress the evidentiary objection to any of the cancellation documents being considered in the trial court or for appellate purposes, given that none of it was produced during discovery. Defendant was obviously aware of this defense before commencement of this action, yet didn't mention it in discovery, didn't mention it in its disclosures. The first time this came up was after discovery closed with the named insured injured person's deposition. Literally during that deposition, when I first heard about this issue, I served a deposition notice while the deposition was still proceeding for the underwriter to investigate this issue. And defendant said, or refused to honor the request and said, no, I'm sorry, discovery is closed. Very simply, defendant may not secret the basis for its defense until the close of discovery, precluding any investigation in the issue into the issue, and then just choose to disclose whatever information it thinks supports its position in a motion that's after discovery is already closed. It's not allowed under the court rules. And with that, unless there are any questions, I'll just reserve a couple minutes for rebuttal.
No questions. You have some
Thank
time.
you.
for rebuttal. Thank you.
Good morning, Your Honors. Matthew Nichols, appearing on behalf of the defendant appellee Progressive. I'm joined today with my colleague, Mr. David Kinzer, to my right. So I know the court's familiar with the case. The court has read the briefs. I think the briefs were very thorough, at least from Progressive's standpoint. I'm not going to stand here today and repeat and rehash what's been put forth on the briefs, but there are a couple main points that I want to make today. I don't see me exceeding my 30-minute time allotment.
You focus on the cancellation issue, because I mean, if you win that, nothing else matters, right?
Well, Judge, to your point, true. If Progressive prevails and this court affirms on policy cancellation, that wipes out plaintiff's claim in its entirety.
Right.
But the argument with the NervoMatrix first,
I know it's a big deal to all of you in the no fault world,
right?
but it's not to us. And we don't just decide issues to decide them. And if you win and there's no coverage, why are we going to talk about something that's not going to get covered?
But one, plaintiff has appealed that order on partial.
That's fine.
summary.
We're asking you
Yeah.
about the coverage issue.
Yeah.
All right. That's
I mean-
what I said beforehand. We're going to have some questions for you. That's what we want you to concentrate on.
Sure.
Okay.
Okay, and with that, and I can touch on the importance of NervoMatrix a little bit later.
Briefly.
You
We're not
can, but
worried
it's not
about
going to
that.
change my mind.
Okay.
I mean,
Okay.
So with
I don't know if you can take that cue or not.
mean, it's a matter of appellate stuff. We just don't do that.
Well, I don't even think we'd be asking for an advisory opinion. I mean,
Why? Because it's totally unnecessary to resolve the appeal. If you win on coverage, there's no coverage, period. They can't collect against you. So what devices they use doesn't matter.
Certainly, I agree with that.
Okay.
But with respect to plaintiffs having appealed that order,
And then
plaintiffs
we
are
just say,
making,
sorry, it's
That's,
moved.
that's fine. Just go ahead. We were asking about the coverage issue. Take the cue.
certainly, Your Honor. So with respect to the policy cancellation, the one, and of course, it's just the one document that Ms. Washington claims she did not receive is conveniently the notice of policy cancellation. She doesn't dispute that she received the progressive policy and the declarations with the onboarding process of applying for the policy. She doesn't dispute that she received the final bill, which was sent regarding her non-payment. And she certainly doesn't dispute the executing the statement of no loss. And that's a critical document with respect to this issue, because in executing that document, it establishes that Ms. Washington had actual notice that her policy was canceled. Again, the relevant statute under the No Fault Act and the policy doesn't require Progressive to prove actual notice. Progressive just needs to establish that notice was mailed. The proof, what was the proof of the notice of mailing? Oh, I'm sorry, Judge, if you were gonna.
I'm sorry, I was talking to myself for a second. Go ahead.
Oh,
Getting old here.
Don't worry about it. This
No.
kind of case makes you do that.
That was an old lady moment, sorry.
well, as a appellate practitioner, whenever I hear a judge speak, my first reaction is to stop what I'm saying and listen.
Best practice, good for you.
So as I was saying, what was the evidence that the notice was mailed?
Right.
The notice itself, of course, and then looking at the account activity.
That's what I'm concerned. The account activity, didn't she go on her computer and didn't it tell her that the policy was canceled?
Was
Yeah,
it
so-
app?
Yep, and nowadays, we can operate through paper trail, but I think most of us operate through computers, and I think more so now our cell phones. And with that technology comes some sort of tracking of that activity, whether we like it or not. I think in this case, it's beneficial.
That's the spreadsheet, right?
Correct.
What, can you address the appellant's argument that that's hearsay?
Well, to that point, Judge Maldonado, we can look right to the affidavit from Ms. Kopik, which I think the trial court properly considered. Not only was it, statements regarding the Progressive's activity or their business records and their business activity, the standards and so forth, but that these things did in fact happen. And again, what are we dealing with from a plaintiff's standpoint? We're just dealing with a simple denial. And as this court knows, a simple denial in the pleadings or a statement of a denial is insufficient to establish a question of material fact. Now, if the case were just simply Progressive saying, yeah, we mailed the notice of cancellation, and that's it, and that's all the proof Progressive submitted, and then in response, plaintiff argues that, well, Ms. Washington testified she didn't receive it, that might be a different story. I know there's case law about the presumption of mailing with notices and how to rebut that presumption with certain testimony from the insured saying I didn't get it. But here the trial court wasn't limited with just those two pieces of evidence. The trial court had.
Can you remind me, how did the court admit that? Was that just as a business record?
I believe so. I don't recall.
Was there an objection to it down
I-
below?
that's what I was getting to, and I don't recall plaintiff objecting to the affidavit in a reply brief.
I'll look it up.
Okay. So on those points, Your Honors, we ask that the court affirm the trial court's ruling with respect to the motion for summary disposition on policy cancellation. If the court would indulge me with a couple points on Nervomatrix.
Quickly.
Quickly? Okay. Again, we're looking at a very limited body of evidence here with respect to a particularized device that delivers essentially electro therapy. The body of evidence as to the device itself is incredibly limited to two medical studies. One being the pilot study, which was done by a doctor who was an investor in the company itself. Two, which admitted we need more. They acknowledged the shortcomings of that study, small sample size, so on and so forth. So what happened then? A couple of years forward, they pay for another study. So one, we question whether that's even objective itself. Okay, but looking at that study, what did it conclude? It concluded that the NervoMatrix device was no better than the placebo. What was the placebo group getting? They were getting nothing. Okay, no therapy, no nothing. And then everything downstream from that, because I know plaintiff referenced there's more evidence regarding NervoMatrix. From a medical clinical standpoint, I'm aware of any further studies either currently being done or that have been done since 2016. So this is the small body of evidence that plaintiffs are attempting to use to state that this device is
I think you did a good job of
efficacious.
briefing that too, so we're.
And on that, there's a clear difference between NervoMatrix and a TENS unit. The key distinguishing factor of the NervoMatrix is it's quasi-autonomous, uses a computerized technology and algorithms to essentially locate the trigger points on the body as to where it will produce the electrotherapy. And that is the part pursuant to the randomized four-blind control study that shows that that part of the machine itself doesn't work. So I don't think it's we're comparing apples and oranges, really.
Any questions, Judge Byrne?
Nope.
Any questions?
Thank you, and
Thank you very much.
thank you for indulging me on Nervo.
No problem. Looking at appellant's table there. Rebuttal?
Very quickly, as to cancellation only, I just want to point out that Ms. Washington did receive some mail from defendant, bolsters plaintiff's position that the cancellation notice was never mailed. But to be clear, of course, I agree, actual notice isn't required. This is a significant circumstantial fact supporting plaintiff's position that it was never mailed as required. Ultimately, the crux is simply whether defendant complied with the law and the very express plain language of its policy, which requires proof of mailing. There is no proof of mailing, even if this court were to consider evidence that is inadmissible, both as a discovery sanction and because it constitutes incurable hearsay as to the truth of the matter asserted, which is that it was actually mailed. And just to be clear,
Can you remind us if there was an objection?
and that's actually my final point, Judge. Thank you. So there was no way to object to any of this evidence until responding to the motion for summary disposition, again, because it was never presented during discovery. This was the first time I ever saw it. And of course, I objected to the court considering it at all. In response to the motion for summary disposition, which I believe is attached as an exhibit to my brief on appeal, I certainly objected and do object to the use of an affidavit proffered by an individual who was never identified during discovery and who defendant refused to produce for a deposition, instead offering only an affidavit. So it secreted all of the documents, it secreted this defense entirely, didn't mention it in its disclosures, didn't provide the identity of this witness, only provided this stuff after discovery was closed. Of course, I objected to the use of all of that. It is in the record here.
Anything else? Thank you, counsel. The case is submitted.
Thank you, judges. Have a great day.
Hey, everyone. We'll take a short break. That concludes our 10 o'clock case call. We'll shortly return for the 11 o'clock case call.
Before the state of Michigan is now in session.
We're back. You guys, there aren't many here. We've read everything. Keep that in mind. We're good to go. We have someone remotely from, I think, up Woodward or down Woodward Avenue. Is Miss White in the queue? Well, I'm going to call the case. Case number 17 on our docket. Case number 371007. Nancy Denamaro Saguna versus City of Detroit.
Good morning. May it please the court, Sherry White on behalf of the appellant, defendant, City of Detroit.
Welcome, Ms. White.
Good morning. I'm going to be very brief. I think our written submissions are clear. Plaintiff's notices failed to provide the exact location and nature of the defect alleged. Photographs were provided after the 120 days. So we would submit that plaintiff has failed to comply with MCL 691.1404(1). And we'd ask this court to reverse and enter judgment on behalf of the defendant, City of Detroit.
Any questions?
Yep, I got a question for you. Tell me what else you would have liked to have had in the notice in order for it to be sufficient.
Well, for one thing, whether the incident occurred on the sidewalk or in the street, even that is not clear here. Anything that would direct the investigator's attention to the location of the alleged defect. The photos that were provided after the 120 days.
Yeah, but
So
the
those
statute
don't
doesn't
count.
require photos. You have that it's shed 5. You have that she's actually walking. I thought it said she was walking across the roadway, but I just want to know, what is it supposed to say? What would have been enough for you not to have disputed it, other than a photo?
Other than a photo? Well, for one thing, as I said, the notice doesn't even provide whether the location of the defect that allegedly caused this incident was on the sidewalk or in the street. So there was nothing that provided our investigators any real guidance as to where to look for for the defect that's alleged here. Photos, no, are not necessarily required. They're, GPS coordinates. There are other things too. Taken as a whole, here, you can't say that they provided the exact location or nature of the defect. Does that answer your question, Judge Maldonado?
I felt like when I read the complaint, because I've been there and maybe that's too much, but I understood exactly where it was. I was trying to figure out what else was needed.
But as you point out, Judge, personal knowledge on any particular person's part is not what controls here.
No, I mean, I've just been to the Detroit market. I haven't looked at where the injury was, but I'm just saying, just going to the Detroit market, if it's by
at Alfred Street near Shed 5, that's a pretty broad area.
Okay. All right. I got it.
Okay, thank you, Ms. White. You have some rebuttal time if you need to use it.
Thank you.
Appellees, counsel?
Good morning, Your Honors. Scott Minnick on behalf of the appellee, Nancy Saguna. We're here today seeking an order from this court affirming the trial court's order denying motion for summary disposition. I know Your Honors have read the briefs. I want to use the beginning of my time just to kind of set the stage. Defendant's motion was filed under C7, C8, and C10. As to C8, that is only supposed to be decided on the pleadings only.
C7 motion, right?
It's a,
Governmental meeting. Let's move on. Come on.
okay. I just, in addition to setting the stage, I want to point out.
All right, my question is kind of like Judge Maldonado's question. How do we figure out where this accident occurred? Even your pictures don't help. I looked at them and they're not part, they're outside the record. That's a wide swath of road there. Shed 5 and Alfred, that's a lot of territory. I don't know. And I think those photos aren't a depiction of what this roadway looked like when your clients tripped, correct?
Your Honor, I agree with that. When she tripped, she slammed her head and face. Her initial thought, and the person she was with, their initial thought was, let's get her to the hospital.
That's fine. Their initial thought is all of that. Go back and show us a spot. I mean, I couldn't figure it out. And like Judge Maldonado, and I don't know, Judge Murray, personal knowledge doesn't count, but I mean, it's a big area.
Sure.
The case law, to add in, the case law says there's one with notice was defective when you didn't specify the north or south side of the road. But in here, there's not even, like Ms. White said, I don't know if it was a sidewalk, I don't know if it was in the road.
Okay, so under the statute, there's no requirement for cardinal direction, north, south, east, west. If you look on a map, Alfred only runs on one side of Shed 5. It can only be between Russell and Ryapel. If it is
city block, Russell and Ryapel is a city block.
So
you go out there and start looking, and it's got to be someplace out there. Let's find it rather than the plaintiffs telling us where it's at.
No, Your Honor, I would disagree. The fact that the notice provided near Shed 5 and Shed 5 only takes up about 50% of that city block. If you look at the purpose of the notice statute, if you look at the language from Plunkett, it's to provide the government agency with an opportunity to investigate the claim while it is still fresh and to remedy the defect before other persons are injured. If someone goes out to Shed 5 specifically and goes on the south side of Shed 5, okay, they don't have to walk the full city block, which would only take 2 minutes. It would take 10 seconds to drive and look. It would take 2 minutes to walk. The shed itself, if you look on the map, that's part of the record that was in our response in the trial court, that shed only takes up about 50%.
How many feet is that?
Your Honor, I never went out and measured with a ruler, nor did my client, but it's a city block in the Eastern Market. It's not a long distance. To walk the entire city block.
Long distance is in the eye of the beholder.
Well, that's what I was gonna say, because I mean, like, the statute says exact location, so it is the exact location. If you look at it, it pinpoints where it was in the city of Detroit. But if you're looking at where it actually happened, is it the exact location? I don't know.
So Your Honor, I would,
You know what I mean?
I understand what you're saying, and I think there's a difference between exact and perfect. If we're talking about a military strike, for instance, you need perfection. You need the exact latitude.
Even that doesn't work.
Sometimes, okay, you need exact latitude, exact longitude. You
don't need that here.
I agree. That's perfect. I would give you another analogy. When you were speaking to sister counsel, and she said we don't specify whether it was the sidewalk or street. We call it the roadway. The roadway is not the sidewalk. When I think of my family in this case, when I'm with my 6 and 4-year-old and we're waiting for the bus with a 6-year-old, how many times do I say, get out of the road? Okay, I think that was specific enough. When we're talking about perfect versus specific, if I'm picking up my wife's dinner order, a carryout order, I know what her specific order is. Medium Greek salad, well done chicken, feta and dressing on the side, dried pita. I have screwed it up myself, but I know that's her specific order. I'm not calling the restaurant and telling them how many ounces of lettuce, how many chickpeas in the salad, how many olives. The city is looking for perfection, and the statute doesn't require it. And under C7, under C10, and under the Plunkett case, the language of the Plunkett case, the evidence is supposed to be viewed in light of the non-moving party. All right. Plunkett says the requirement should not receive so strict a construction to make it difficult for the average citizen to.
Substantial compliance will suffice under Plunkett.
And we have substantial
Okay.
compliance here.
I think we understand your argument.
Okay,
All right.
and I just, the last point in comparison to a lot of the cases, and we differentiate in the brief, but the most recent one, the Mawback case that Judge Maldonado sat on, that in that case, this court said there wasn't substantial compliance because there were no witnesses listed. There were no, it said
I think Judge Murray was on that too.
there were no witnesses
Right.
listed. There were no, it just said personal injury. There was no injuries listed.
Right.
It said an intersection. It didn't say which corner of the intersection. This was not an intersection. This was, she was crossing the roadway. Okay. So substantial compliance, the city doesn't even take issue with witnesses or nature of the injury. So we're already at 50% compliance there. Here, we specifically say she's walking across Alfred Street near Shed 5. Okay. There's only one side of Shed 5 that Alfred Street runs across. So it's not a big area. It's at most a 2-minute walk. All right. And then as to the nature, we indicate that Ms. Saguna was caused to fall due to uneven cement / roadway. All right. That is indicative, number one, that occurred in the roadway, not on the sidewalk. I don't think there's any grass there, but not on anything else. It's indicative that it was on uneven cement, not asphalt, not gravel, not brick pavers. This notice substantially complied.
Yeah,
And-
that one didn't even tell you what was wrong with the roadway either.
Correct.
No witnesses, no injury, no exact location, and they didn't have what was wrong with the road as well.
And if you look at the history of the statute, one of the cases they cited was back from the 1960s, and I took note of it because the statute used to only require 60 days. They've loosened it up. Now it's 120 days. So I understand, and it's clear that exceptions to government immunity should be narrowly constructed. But as it relates to the notice, it's not the same narrow construction as it is with the exceptions. The notice, the tie, and I don't even think this case is a tie, but the tie should go to the injured person who has this short period of time to give a specific location and nature. And in these notices, because there was two, one corrected the date, these notices substantially comply. I mean, I think it's specific.
You're kind of repeating yourself.
Okay, so then I'll stop now.
We got the point. I mean.
Yeah.
We got, but that dinner your wife has certainly sounds delicious.
If you get it right.
Yeah, that's what I say. You better get it right.
You get it right. I used to be 6 feet tall, so thank you, Your Honors.
Thank you very much, Mr. Mitnick. Ms. White, do you have any rebuttal?
Yes, just very briefly, Your Honors. And it's interesting that the plaintiff's counsel refers to the reference to roadway. The statute also requires, and we point out, that a claimant specify the exact nature of the alleged defect. And here all we have is uneven cement / roadway. That goes in no way to telling us whether we're talking about the sidewalk, the road, whatever. So it's interesting that he should bring that up. So the notice was defective in that respect also. And plaintiff also seems to think that every single requirement of the statute has to have been failed in order for a case to be dismissed. I don't think I've ever heard anybody argue that. Under the statute, the notice requires what it requires. And here, it does not provide the exact nature or location of the alleged defect. This is very straightforward. Summary disposition should have been granted, and we would ask that the circuit court's ruling be reversed and that judgment be entered on behalf of the city.
Okay, any more questions? Thank you, Ms. White. The case is submitted. Have a good day.
You too. Thank you.
Thank you.
You're welcome.
Nice to meet you, Mr. Mitnick.
Nice to meet you.
Calling number 18 on our docket, case number 374097, N-Ray CCM Baskin minor. And Ms. Gilfix is endorsed, but I don't see her here. All right, the case is submitted on the briefs. Calling case number 19 on our docket, case number 370326, N-Ray BM Ortiz minor. And there's somebody at the podium.
Good morning, Your
Morning.
Honors. If it please the court, Attorney Sharon Jones. I am the attorney for Lisa Marie Ortiz. I don't have much more to add to my argument. Well, nothing really to add. I would just bring to the court's attention, our position is that the lower court should have given more weight to the value that the child placed on her relationship with her mother and her sisters, and that the parental rights should not have been terminated. That's her position.
Any questions?
No, thank you.
Thank you, Ms. Jones. Have a good day.
Thank you.
Or she's next.
So,
Oh, you're next? Oh, my goodness.
A busy day.
I should be reading. That case is submitted, but have a good day still.
you.
Calling case number 20, case number 371631, N-Ray L.A. Ladie minor.
Thank you, Your Honors. If it please the court, Attorney Sharon Jones, on behalf of Mariah Faith Ladie. She's the appellant mother in this case. And before the Lumbee Fairness Act was enacted into law in December, I argued that this was a
Federally recognized. Yeah.
right. And so now that I would argue that that issue is moot under the Lumbee Fairness Act. This court took judicial notice of the Lumbee Fairness Act, which is part of the NDAA. I also wanted to point out the Michigan Indian Family Preservation Act provides under 3 sections of MCLA of the act, Michigan Indian Family Preservation Act, 712.
You could just say MIFPA.
Okay, MIFPA, 712B.7, Section 6 says that a child's tribe has the right to intervene at any point in a child custody proceeding.
That's my question. What's a proceeding?
Even this,
Why?
counts.
Would a proceeding just be the trial
no,
court?
no, that has not been how the act has been applied. To my understanding, would include this.
Do you have any case law on that? I'll let you, I'd allow you to file a supplemental brief.
I would like to, it happened so
It'd be up to the
recently.
court here. I mean, all three
Right.
of us.
Right. I would like to submit an additional short brief on the question that you asked, because I don't have case law handy. I can only reference MIFPA and ICWA at section USC 1911, section C, which says that a Native American tribe has the right to intervene at any point, and MCR 3.905D, which mirrors MIFPA.
So I agree. I think they have that if the tribe filed a motion to intervene in these proceedings, they could do that. But that is different than the notice, the deficient notice requirement, because the notice is for the lower court proceeding. That's where MIFPA and ICWA require the filing of the notice to the tribe.
Yes, it's section 712B.9, subsections 4A and 4E. Yes.
I mean, because I think you kind of, in your oral argument, you just conceded that at the time that that case was pending, um, the, the Lumbee had not yet been federally recognized. Is that because you said it was moot?
I don't concede that
Okay.
that's what should have occurred. Because there were developments in 2016 that recognized that corrected certain hurdles the Lumbee tribe had to overcome that put their federal recognition into question. Those were removed in 2016. It doesn't require, it's federal recognition. It doesn't say it has to be the BIA.
You're saying it doesn't have to be on that list, right?
Right.
But see, the problem is under federal law, there actually is no settled definition of what is a federally recognized Indian tribe. And so I forget what year, but they passed the BIA, the List Act that requires the Bureau of Indian Affairs to publish and update annually a list of all the federally recognized tribes that are eligible for services. And so after that point, because there was a lot of confusion about which tribes were and weren't federally recognized, and there was some very unfair, disparate treatment. In fact, I believe this tribe was unfortunately in the wake of part of that.
Yes.
And so the List Act was supposed to, it doesn't recognize tribes, but it was then used as a focal point for future statutes. So when they were written, if you look at the definition of Indian tribe in ICWA and MIFPA, it says that an Indian tribe is a tribe that is eligible to receive services under federal law, right? And so that's what had to be in the record. The easy way to do that is to go to the list, is to go to the list, because that's there's other ways though that you could potentially do that there, but we don't have that in the record. Down at that point, we don't have either that they're on that list, which is a very simple, quick way to verify that the tribe has service, is getting federal services, or any other evidence that the tribe was getting federal services. So did I miss something in the record that would point me to that?
Your Honor, given the recent developments and given what ICWA and MIFPA are designed to protect, which is the Indian child's relationship and cultural ties to the tribe, we should not rely on perfunctory lists and whether that was done within a certain time. The law just changed to clarify the Lumbee tribe's recognition. This is one of the oldest tribes in the United States. And at the time they sought federal recognition, the country's view on recognizing tribes was at a different stage. The country was trying to move away from that. So the timing was off for the Lumbee tribe, and now that's all been corrected. Congress has given us this gift of clarity of showing that the Lumbee tribe should have had full federal recognition all along. And in 2016, the steps were also underway. Both presidential candidates were touting how they would correct this wrong. And Michigan's position has been, when a law has changed on direct appeal, appellant should get the benefit of that new law. And I only had criminal cases to cite for that. If I have the opportunity to brief it, I could look further for something that's more relevant to child protection. I just don't have that right now.
Let's see, Judge Maldonado would be equipped to answer this, I guess, but let's say we do say, well, look, the send it back to the trial court for compliance with the MIFPA and ICWA notice provisions. That's all it is. We're setting it back for the notice provisions, correct?
But there's so much more that entails. The standards for how the case proceeds are different. It's not by clear and convincing. The standard rises to beyond reasonable doubt. The court took a very relaxed view on the rules of evidence with regard to the tender years evidence that was presented. There was testimony about a child being dragged across nails, but there was no evidence, no medical evidence. It was just the tender years evidence of that with no, even though the child was examined, there was nothing to substantiate the testimony that the examiner provided, which is different than what the child had been saying before. She had been questioned multiple times before talking to the examiner. She said the exact opposite before, and then after talking to the examiner, all of a sudden, she was dragged across nails and had scars on her knees that the workers hadn't seen before until testifying at trial that this child told them just before they sent her to the examiner. And so it would be a completely different standard. The evidence would have to be better presented than it was to take my client's rights to her son.
Yeah, she'd be entitled to active efforts, and then the standard for
qualified-
termination is higher as well.
Right, and a qualified expert witness for, yeah.
I'm gonna go back. It's a 4-year-old child, I think, correct?
This case was a little complicated in that the child at issue is her son. I believe he might be 4 years old now, but the testimony was from her daughter.
Who she
Because-
was already terminated.
Right, her rights to her daughter were terminated, but her life had turned around and she got her daughter back through an odd set of circumstances.
Yeah, the father ended up going to prison, and DHHS was aware that she had the child.
Right, and they
Yep.
were supporting her in that, and they approved of her home. She was working. Everything looked great until this allegation came up.
No, you did a good job briefing it.
I guess we'll let you know about supplemental briefing, okay?
Okay,
We'll issue an order on that if we're gonna do it.
okay, thank you so much, Your Honor.
All right, do we, anything else?
No, thank you.
All right, thank you very much. Case
care.
is submitted. You're done for today now, right?
Yes,
All
thank
right.
you.
It was helpful to have you here. Thank you.
Okay.
Yeah,
good.
very helpful.
Yeah, I appreciate it.
Okay. thank
This,
you.
all right, thank you. The case submitted. Going next to the next case on our docket, it's number 21, first for their 2-day case call. Case number 374624, N. Ray N.L. Bennett minor. There being no parties endorsed, the case is submitted on the briefs. Calling our final case, number 22, it's case number 371277, N. Ray M.S. Threet minor. There being no parties endorsed, the case is submitted on the briefs, and that concludes our case call. Thank you very much, Vince and everyone else.
Thank you, Ben.